Well, let's turn to this distinction now between law and legislation, which I learned about from you, and you in turn learned about it, I think, from Hayek. I found it very puzzling at first. Don, in our casual conversations, I would say, oh, Congress passed this law the other day to do such and such, and you'd say, no, that's not law, that's legislation. And you relentlessly correct me, and I now pretty relentlessly correct myself when I misuse the word law to equal legislation. But in everyday language, we equate the two. We use the words interchangeably, but you and Hayek think that's a conceptual error. Talk about that.
Yeah, and before I do, we even talk about legislators as being lawmakers. That's a common way that we refer to them, and I think that's a mistake. Hayek's distinctions is a summary of a fairly deep and complex topic. Legislation are consciously designed rules that may be of general application, they may be a very specific application, but they're consciously designed rules that are enforced basically at the point of a gun by a sovereign. If you don't obey, you get shot ultimately. Law
or put in jail, or
but ultimately get shot, because if you resist, if you resist jail enough, you'll be shot.
I guess that's true.
Yeah, but it's the legislation is enforced with the threat of force, threat of violence. Law is the emergent patterns of behavior that become incorporated into most people's expectations, and that can be enforced with threats of violence, but are not necessarily enforced with threats of violence. Let me give you much of what looks like legislation is in fact law. If Congress or if the legislature merely codifies certain widely recognized patterns of expectations, that's just a codification of law. Hammurabi's Code, Hayek discusses that. Hammurabi's Code is not a piece of legislation, at least not by and large. It's a codification of existing law. But one of my favorite examples of law, and you and I have talked about this, is actually I get this from my old teacher, Randy Holcomb, who's been at Auburn University. He had the observation that you walk into a school cafeteria at lunchtime and you want a place to sit. You're a student or a faculty member, and you notice it's very crowded and there's a long line to get food. And what people do is they take their books or their backpack and they put it down on an empty chair or on the table just in front of an empty chair. And they go wait in line and they get their food, and 10 minutes later they come out, and sure enough, no one is sitting in that chair. That space is reserved for that person. Even though it's probably the case, it's almost surely the case, that had that backpack with those books not been put at that space, when you would have come back to that space, someone else would be sitting there. So someone came by before you, while you were in line, but before you came back, and looked for a place to sit, noticed your books, and walked away disappointed because they knew that those books reserved that space. Now, this is law, in my view. This is a beautiful example of law. It's not written down anywhere. You can. We're in Virginia here. I'm sure there's nothing in the Virginia statute book. There's no decision by the Virginia Supreme Court. It's not in the Virginia Constitution. There's nothing in the U.S. Code. Not in the George Mason handbook or student handbook or faculty handbook that says books reserve places at a table. But we all recognize that pattern of behavior. And it's true, it can be violated. Laws are violated all the time. Just because a law is violated doesn't mean it's not law.
But the key point here is that you have an expectation.
You have an expectation.
That's likely to be an accepted way to lay claim to that piece of that seat.
That's right. If you put your books down, think about it. If you put your books down and you come back and you see your books moved aside and some stranger sitting there eating, it's a small thing. You probably won't make a big deal out of it.
Not going to have a fist fight.
But you feel that there's been some violation there. Another example, I blogged in this a while back at Cafe Hayek, are speed limits. Lawyers talk about black letter law. And there's no...
What do they mean by that?
Very plain, by-the-letter law. Without any of the nuance.
55-mile-an-hour speed limit's pretty.
It's literally black letter or black numeral law. And so you're driving down the highway and it says 55. And the traffic is not unusually heavy. Your car's in good repair. The weather is decent, and you're driving 60 miles an hour. Are you breaking the law? Well, if you interpret law as what the legislature says, what's written down, well, you're breaking the law because it says 55. Cop pulls you over and says, you were going 60 miles an hour. And you say, well, yeah, so what? And he says, well, what part of 55 don't you understand? And, you feel, if he gives you a ticket, you feel like there's something wrong because and he knows, and he knows. The expectation is that people can drive 5, 6, 10 miles an hour.
I think most of us act.
Well, that's why I chose 5. You can drive 5 miles an hour over the speed limit, and you're not really breaking the law. Now, if you're going 95 miles an hour, in both cases, you're upset that you get pulled over,
right.
But you don't feel like you've been wronged.
Correct.
You've broken the law and you got caught, and so that's an example where what is written down in the clearest possible terms is not really the law is something different. The law is you can drive above that. In the case of the books and backpacks reserving cafeteria tables, nothing's written down at all, but it's an emergent law.